Good evening, everybody. My name is Harry Shipley. I'm the Assistant Executive Director here for the Iowa State Bar Association. I wanted to welcome you here tonight to our 6th edition of our People's Law School. The concept behind our People's Law School is to somewhat demystify the law so that individuals aren't fearful of the law or fearful of going to an attorney. So hopefully this evening our resident experts, Hope Wood and Matthew Gardner, will give you a good education on wills and the revocable trust concepts, and you'll find your time here worthwhile. One thing I did want to point out before we kick off is what you see here in front of you is our Iowa Find a Lawyer site. This is a site, it sounds like it's just to go find an attorney, but it's much more than that. This is our public-facing site for the public, and we would encourage you to go visit this because there's a lot of self-help forms, videos, a variety of pamphlets and brochures to help you better understand the process that you may be undergoing, and so on and so forth. And I also wanted to remind everybody that this evening's event will be recorded. So we ask that you kind of keep your questions to the end of the event, and then at the conclusion that this recording will be placed on this same Find a Lawyer site for your future reference. So if there's something that you heard this evening that you want to follow up on, you can go there. And with that, I'm going to hand it over to Hope.
Good evening, everyone. My name is Hope Wood, and I'm happy that you're here tonight. I actually see some faces that I recognize, which is always great. I really enjoy doing public presentations and educating attorneys and non-attorneys on the topic that we're going to talk about tonight. I'm here with my co-presenter, Matt Gardner, and he is one of my mentors. I've been practicing for 6 years. Matt has been practicing longer and has a great reputation in the community of estate planning attorneys. And so a lot of times when I have questions or want to check up on something, Matt's one of the attorneys I go to, so I feel very honored to be up here with him. The only reason we're going in this order is because I said I wanted to talk about these the first two topics, which are wills and probate. Like I said, I've been practicing about 6 years, and I have a practice downtown Des Moines, and primarily work doing wills and estate planning. So I'm just going to go through what we're going to cover. I have 30 minutes, Matt has 30 minutes, and then we're going to have time at the end for questions. So please write down questions that you have so that we can address them at that time. These are the areas that I'm going to cover that you see on the screen. I do tend to elaborate a little bit long on my PowerPoint, so there's a couple slides I'm going to skip over and go back to if we have time. I put together a couple of examples, and I will use some of the examples to explain and help more fully educate you on the topic, but sometimes I go a little bit overboard on the examples because I find them interesting. So I'm going to skip over a couple slides possibly, and then if I have time, I'm going to go back. So first topic is what a will can do. So you maybe have been told that a will is necessary for fill in the blank. And a will can do a lot of things. Listed here, I have 4 of the things that I believe are important parts. It provides a contingency plan in the event that there is an asset that doesn't have a joint owner or a payable on death beneficiary. So in the event that happens, a will is going to transfer your asset to who you have named in the will. If you have minor children, or if you have adult children and they have kids, so you have grandkids, your children or any adult that has minor children can list a preferred guardian in their will. In the event that the parents are both deceased. I'll get into that a little bit later. A will can create a testamentary trust. We'll also get into that later. And it can control how your personal belongings are distributed. So if you I'll give an example of an estate that I had where the parent told the child, when I die, I want you to have this specific vehicle. But the person did not put that in their will. And so what ended up happening was when they had the estate sale, that vehicle had to be sold, and that child that said it was supposed to be theirs had to buy it from the estate sale. So if you want something that you own to go specifically to somebody, you can put that in your will, and that is an enforceable way to make sure that asset gets transferred. There are a few things that a will does not do. Oops. It's fancy technology. Okay, so a will by itself does not avoid probate. And probate is a court-supervised process. So if there is a specifically titled asset that cannot transfer through a contract or a payable on death designation, then it has to go through the courts to transfer. And that's what it's called, the probate court. So a will by itself doesn't avoid that court-supervised process. It all depends on what assets you have and how they're titled. I'm going to go into more detail on that. So a will does not by itself avoid probate. A will does not allow for 2 steps for a transfer. The example I give here is you can't put in your will, I want my house to go to my spouse, and then when my spouse passes away, I want it to go to my children. Only that first step is available under the will. If you want to do 2 steps, then you have to go with a different option. Okay, so here's my first example. And this is going to get into a little bit more than what I've already talked about, but I wanted to address sort of the complexity of the different types of assets to just give you an indication of what's going to be coming up next. So we have a single person. He owns a home. He has a 401k with a named beneficiary. And the beneficiary he's named as his sister. He has a life insurance policy, and the beneficiary named on that is his girlfriend. And he has a checking and a savings account with a payable on death to his parents. In his will, Gus has a will, he gives everything to his sister. Now, because of the way the other assets are titled, with a beneficiary, with a payable on death, his sister is not going to get everything. She's not going to get all of his assets. And as you can see in the bullets, the parents are going to get the checking and savings account, subject to the creditor claims. The sister is going to get the house subject to the mortgage, and the girlfriend is going to get the 401k. Because the home is owned by one person, just Gus, when he dies, that immediately, or at least under Iowa law now, will require the court to have a probate process. So an estate has to be opened with the court because of that real estate property, because there is a home owned by one person, and in Iowa, if there's real estate that's owned by one person, it has to go through the court-supervised probate process to transfer. And because there's other assets, in addition to that home, those are also included in the probate estate, and they're subject to potential creditor claims. Doesn't mean that they're not going to receive that inheritance. You know, the girlfriend is still going to receive the life insurance policy, but the 401k, if there's a lot of creditors and they have a claim, their claim is going to be superior to the beneficiary. And I'll get into that in more detail. So this sort of gives an example of how complicated it can be. So I'm going to break down how these all work. Okay, so a common thread you're going to hear me say is when an asset is owned by 2 people, it's going to transfer probably to the joint an exception to this is the way that real estate is owned. Oftentimes, especially in a spouse situation, the spouse is going to be a joint tenant with a right of survivorship, which means when one of those one spouse passes away, it automatically transfers to that surviving spouse. And the way you know if it's a joint tenant with right of survivorship is it is often written that way on the deed to your house. An exception, and this is where it's really important to use an attorney or consult an attorney, if you don't want it to transfer that way, you can title your home as tenants in common. And with tenants in common, the ownership of the deceased person does not transfer to the other tenants in common. It'll transfer according to that person's will, or according to, if they don't have a will, according to Iowa intestate law. I have seen one estate with the tenants in common, and so I got to do my, my legal analysis on that. Again, I just recommend using an attorney to make sure that that's what you want to have happen, because in that case, the home had to go through probate to transfer. Okay. All right, so, Christy, is there a way to tell the time? I want to make sure I don't go over. Okay. Okay, perfect. Again, I tend to get winded sometimes, so I want to make sure I cover what I should cover. Okay, so if an asset is owned by one person, it's controlled by the will unless it has a payable on death designee, and that is often seen with a bank account. In order to get a payable on death designee, you would go to the bank and fill out a payable on death designee form. And you would name who you want to receive that money from that bank account when you pass away. If you don't have one of those, and your bank account or your total assets at death are more than $50,000, then an estate has to be opened to transfer the money in that bank account. If the bank account's owned by two people, which I'll get to next, then it's going to transfer to that joint account holder. So that makes it a little bit easier. All right. If an asset's owned by one person, it's controlled by the will unless there's a transfer on death designee. I often see that with an individual stock. So you can, if you own, so for example, some employers issue stock as a benefit. So it's often only owned by one person. So I know Facebook does this. Meredith used to do it. John Deere maybe used to do it. I'm not sure. But if you own stock as part of through your employer, and you're the only person named on that stock, then you can complete a transfer on death designee to name who you want to receive that stock when you pass away. It's a form that you have to actively complete. It just doesn't happen as part of it. Typically, it doesn't happen as part of it. So if you own that stock by yourself and there's a transfer on death designee, then when you pass away, that stock transfers to the person that you've named. And the stock stays active until that person can decide what they want to do with it. If an asset's owned by one person, it's controlled by the will unless there's a named beneficiary. This often happens with a 401k, an IRA, life insurance policy. The beneficiary has to be alive to inherit it. If that beneficiary isn't alive, then it goes to the alternate beneficiary if they're named. If the alternate beneficiary isn't named, or isn't alive, or isn't named, then the will is going to control who receives the money from that 401k, or even the life insurance. I have had that happen where somebody had an employer life insurance policy, and they actually didn't know that they had that as an employee benefit, and they'd never named a beneficiary, and the employer didn't ask them to. So that makes it pretty complicated. So one thing you can do is look at your assets and see if you're the only owner on the statement. We're all getting our third quarter statements right now from financial institutions. See if you're the only person named on that account, and then contact them to find out if you have somebody named as a beneficiary and if you can name someone. And then I also recommend naming an alternate so that you have a contingency plan. An asset owned by one person is not controlled by the will if that asset's held in a living trust. Okay, so real property, which is real estate, with two owners, if it's owned by two people as joint tenants with rights of survivorship, as I already mentioned, by law, when one of those joint tenants dies, it automatically transfers to the surviving joint tenant. And they don't have to be spouses. It just depends on how the deed is written. So if it's joint tenants between a parent and a child, or two people that are in a relationship but not married, if both of their names are on that deed as joint tenants with rights of survivorship, then by law, the person that's the joint tenant that survives the other person is going to receive that asset. It doesn't matter what is in the will. So that's how the joint tenancy with rights of survivorship works. Tenants in common, it doesn't go to the surviving tenants, as I mentioned earlier. The percentage that that tenant owns, whether it's 50 or a third, that interest, if they're tenants in common, can be transferred by the will. And if there's no will, it'll go by intestate laws. I listed some examples of real property, some things you may not think about, because if it's not your homestead, maybe you don't think about how it's titled. So homestead is where you live. If it's in joint tenancy, I explain what happens. You may have a timeshare, and if you have ownership in that timeshare, even if it's like a percent interest of 1 week out of the year, the joint tenant is going to inherit that. Whether or not that still needs to go through probate depends on where that timeshare is. So if it's in Iowa, it's controlled by Iowa law. If it's in a different state, then you have to use a different, an attorney from that state. Because we're only they have to be licensed in that state. If you have rental property, so if you own property and you rent to somebody else, that means you own it. And if it's held in joint tenancy, same thing applies. It'll go to the surviving joint tenant. It's better, this kind of goes outside the scope of this, but if you rent property, it's better if you actually put that property into a business entity, because the business entity doesn't die. So that's something that is outside the topic, but just wanted to, if you have that situation, probably good to talk with an attorney about maybe moving that into ownership into a business entity. And these are all examples of personal property. So there's real property, which is your real estate, and then there's personal property. Whoops, sorry. Personal property, which is almost everything else. The other category would be intellectual property. If somebody owns art, copyrights, prints, Aretha Franklin, those kind of intellectual properties. I'm not even going to get into that. So we're just going to talk about real property and personal property here. Some things to think about with personal property, in addition to the assets that I talked about already, are cash itself. Maybe it's in a safety deposit box. And vehicles are personal property. Okay. So I covered a lot of this already. If an asset's owned by one person, you can complete a form with that financial institution, if it's available, to have that asset transfer what we call outside of the will. So that bank account with a payable on death designee will transfer to that designee outside of the will itself. So these are some ways these are some forms that you can use to do that. Savings bonds is one thing I haven't touched on, but a lot of times those are owned by one person. I did have an estate once that had to be opened because there were bonds held without a payable on death designee, and the bonds exceeded the $50,000. And I'll get into that in a second, why that $50,000 is important. And then these are other assets that, if they're owned by one person, you can complete a beneficiary form. And again, kind of being redundant, but hopefully it helps get the point across that if there's one owner, then it's controlled by the will unless there's a payable on death, transfer on death, or a named beneficiary. Now, as I said before, real estate with one owner is always going to require the probate process to transfer. It's just the way the Iowa law is written, and there's ways to work around that. Matt will probably get into that with his presentation. But if you own real estate by yourself, that will automatically require the probate process to transfer. If there is no real estate and the total amount of assets is $50,000 or less, the beneficiaries that are entitled to those assets can complete a small estate affidavit. And I put the code section for Iowa that governs that. There's specific things that have to be listed out. It's best, even though all those requirements are listed in the code section, it's best to have an attorney draft that so that there's no problems later. And there is no transfer on death deed in Iowa, so there's no kind of TOD for real estate. Okay, so I'm going to skip the practice problems. You do have them in your handout. And I'm going to go to probate. I'm going to go to guardianship real quick. So I'm on slide 23. Okay, so if there are minor children that are affected by the death of a parent, the preference for guardian under Iowa law is always going to be the biological parent, if they're qualified and suitable. So for example, if the parents are not together, let's say one parent is with the child, the other parent is incarcerated, and the one that's not incarcerated dies, the parent that's incarcerated is not qualified to be the guardian at that time. It doesn't mean that once they get out, they can't qualify, but they wouldn't be able to be a guardian of a minor while they're incarcerated. So hopefully that parent has a will that states their preference for an appointed guardian, because in the code section that's listed here, if you list in your will who the preference is for a guardianship appointment, then the court is going to give that person a look first. So let me give an example. Okay, so we have a father who is single, one child under 2 years of age. They have to be under 18. These 2 years doesn't actually make a difference. They have to be a minor. Saul dies. Biological mom has been uninvolved with the child's life, and there's no custody agreement. Saul's will names a guardian, and so there's a guardianship proceeding in court. The mom has to get notice because of the preference for the biological parent. The court will not appoint the person nominated in the will if the biological mom is qualified and suitable. So it's still good to always put it in the will because you never know the situation that's going to come up. But regardless of whether the biological mom was involved or not, if the court finds that she is qualified and suitable, she's going to have guardianship over the child. Okay, so going on to probate, I've talked a little bit about how this is a court-supervised process. And the reason for that is because the legislatures want to protect the assets of the deceased person. They want to make sure that the assets go to the right people. And so if there's no protection by way of a beneficiary, then they want the court to supervise the transfer of the assets. So if, let's say, the example I've used, there's real estate owned by one person, so somebody has to petition the court to open the estate. If there's a will, the executor should do that. They should petition for the court to open the estate, to accept the will as valid, and to appoint the executor to take care of the estate. The will can waive bond, which saves some time and some money. If there is no will, somebody still, and let's say we'll use the same example, there's real estate owned by one person. If that's the case and there's no will, then anyone who is qualified can petition the court to be appointed as the administrator. And the administrator does similar work as the executor. It's just that they haven't been listed by preference in somebody's will. And what can happen is sometimes several people may apply to be the administrator. For example, both children who don't get along. So one reason, good reason to have a will, name your executor to keep that out of a contested issue in court just from the outset. If there's no will, all of the heirs that inherit have to waive bond. And the court has to find that waiving bond doesn't prejudice any of the creditors that may have a claim against the estate. And then there's a couple other bullet points about what happens next in the probate process. I have 2 single-space pages of things that have to happen in an estate, and so it's essential that you hire an attorney to help you as the executor, as the administrator, to take care of the estate itself. If an estate is open, the executor or the administrator has to give notice to any creditors that are known. If there's a house, there's likely a mortgage, and so the bank's going to have to get notice. So they'll get notice by mail if they're a known creditor. Because you may not know all the creditors, publication is required in the newspaper where the person where the person died. Publication has to be in the paper for 2 weeks. And also there has to be a notice to Iowa Estate Recovery in case that person was on Medicaid, because the state has an interest in recovering those monies potentially. There is availability under Iowa law for a spouse to elect to receive a certain distribution. That gets kind of into more specifics, but if you want to exclude your spouse in your will, you can do that, but that spouse may still have a right to inherit part of the estate. Also, that may not be available if there's a prenuptial agreement. So that gets into a little bit more than what we're going to discuss tonight. But that is something that can come up. The inventory has to include all the assets, even if Like the real estate is the only reason that the estate is open. It still has to list all the bank accounts, all of the assets, and who's supposed to receive them. And one thing that sometimes comes up is people are encouraged to get to do estate planning to keep it out of probate so that it's not available to the public, that information. So this inventory that you have to file as part of the estate is available to the public. And people can get nosy. And so that may not matter to you, but that is something to be aware of, is all of the assets and their amounts and who's getting them can be viewed under public records. Okay, and then I go into some detail here about the estate returns, or the taxes. Sounds like my timer. So there is no specific death tax in Iowa. The taxes relate to, there has to be income tax paid for the year that person dies, if they're required to file. There's inheritance tax for certain people. Spouses are exempt, children are exempt, there's other exemptions. So that's in Iowa. And then there's a federal estate tax right now if your estate is valued at $11.4 million. Now, another reason to do some estate planning and try to keep your assets out of that probate process is that the priority of the beneficiaries receiving their inheritance is literally last on the list. I have a list of who gets paid first, and this whole first slide are people that are not the beneficiaries. And at the last part of the slide, then the beneficiaries inherit. So basically, everybody gets paid, and what's left goes to the beneficiaries under the probate process. A final report's required before the estate can close. That gives notice to everybody that maybe thought that the estate was handled incorrectly. So if you're a beneficiary, that's something that you can look into or have an attorney look into for you. And then an accounting of the estate has to be filed, which is all the money that came in and went out of the estate as assets and debts. And that's my part of the presentation. Here's some information about me, again, in your handout, and I'm going to turn it over to Matt.
The two topics that I'm going to cover tonight are dealing with court costs when you're dealing with the probate process, so kind of finishing up a little bit about what Hope was talking about. And the second topic, which is the hot topic, is the Revocable Living Trust, which seems to get a lot of questions and discussions. So this is normally a 3-hour presentation, but we're going to consolidate it down to half an hour. So we'll do our best to cover some of the basic issues, and then, like Hope indicated at the end, we'll have about some time, 30 minutes set aside for some questions that might pop up. So with that, court cost. When you utilize the court system to go through the probate process, there are costs that are involved. We got to pay for the judges, we got to pay for the staff, we got to pay for the building, we got to pay for the janitors and utilities and so forth. So the court system charges fees to utilize their court process. Those costs are based on the size of the estate. So those larger estates that are going through the probate, they end up paying a higher portion of those costs that are used for the court systems. Because the value of the estate, it's not the net estate. So if you have a $1 million estate, but you have $900,000 of debt, it's still going to be $1 million estate, and they're going to tax it on the court cost based on the $1 million size of an estate. So it's not just the net estate, and it's not just probate assets. Like Hope was going through her presentation, she said there are some assets that will go to beneficiaries, like a life insurance or retirement accounts that will go to a named beneficiary. So it doesn't go through the probate court process. Your will doesn't control it, the beneficiary designation controls it, but that doesn't matter. It's still subject to the court cost calculations. Now, there are a few exceptions on how those costs are calculated. On the slide, we referred to as small estates, and there's the Iowa Code Section 635. One of the benefits of the internet is that you can find out a lot of information out there. Some of it's correct, some of it's not correct, some of it's halfway correct. But if you wanted to find out what Iowa Code Chapter 635 says, you can go out to the internet and find information. But basically, small estates are states that are probate assets of less than $100,000. So if you're the decedent's estate, the probate assets, the assets that don't have beneficiaries, they don't have a joint owner, they're going through the probate process, if they're $100,000 or less, the court costs are going to be calculated in a different process. Much different, actually. There's a $15 filing fee, which really doesn't cost much to do that, and then there's a few other miscellaneous fees that the courts will charge, but at the end of the day, you can kind of guesstimate that the court costs for a small estate are going to be approximately $60. Sometimes they'll be higher for various reasons, but roughly speaking, for small estates, we're kind of in that range. For all other states above $100,000, we consider those regular states. I should preface this that everything that Hope and I are talking about tonight are dealing with Iowa law. That's obviously because we're at the Iowa State Bar Association office. So what they do in Missouri or Nebraska, God forbid Nebraska, but what they do there is going to be different than what we do here in Iowa. So be careful about the information that you communicate to other people in other states, and be careful about communication or information that you get online, because it may be very different as to what they do in those other states. So going back to Iowa regular estates. In Iowa, the regular states, again, more than $100,000, they're going to be calculated on a schedule which is set by a statute, which is Iowa Code Section 633.31, and it's based on the size of the estate. For many years, I never went through and calculated this fee, what it was for the estate. You just called up the clerk's office and said, what's the cost? And they'd tell you that fee, and you would put that fee down, you'd write a check. And after a while, I started wondering, it didn't seem like there was a lot of consistency between the different counties, because I thought I had a estate of a similar size, and I called up the clerk and I got a different number, and then I called another county and I got a different number. And that's kind of been a problem. We'll get to that in a second. But basically, at least for here in Polk County, court costs in your handling a traditional estate, it's about 0.3% of the total estate. Again, all of the assets, disregard debts, we include named beneficiaries, but basically it's a 0.3. It's not going to give you the exact figure, but it kind of gives you an idea as to what you would be looking at when it gets time to calculate those court costs. So to kind of walk through an example, let's say a decedent passes away and they own a house that was valued at $300,000. They had a mortgage of $200,000. They had some miscellaneous property, cars, bank stocks, bonds, and let's say it's $500,000. But they had some debt, $25,000, and they had an IRA that had a named beneficiary that went to their kids. So, Matt, what are those court costs going to be? Well, the court costs and the referee fees come up to about $4,900. I put in some tricks in there just to see if you were catching them, but I put in that there's some car loans and some credit cards and other debt. That doesn't make a difference. So you can ignore that when you're calculating those court costs. Like we said, the IRA, that was $600,000. That was a large chunk of the estate that even did not go through the probate court. The court was really not involved in handling that asset, but it still gets calculated for the court cost. So again, that's $4,900 to give you an example of what it's about a $1.5 million estate would be. Not everybody has a $1.5 million estate. So another example here is example 2. Let's say the total estate is $500,000. Again, total estate's going to be the house, the retirement accounts, bank accounts, cars, vehicles, whatever. In that situation, those court costs are going to be $1,800. still a decent chunk of change, but certainly lower than the larger state. So I mentioned before about counties are different. This is something that the attorneys in Iowa are aware of, and we've had some challenges in trying to get some consistency across the state of Iowa so that whatever they charge in Pottawatomie County is going to be the same what they charge here in Polk County, and so that all 99 counties are doing it the same way. But unfortunately, that hasn't happened yet. We're also trying to modify it and clarify that certain assets should not be included in the calculation of court cost. Like, for example, those retirement accounts, the IRAs, where they're not going according to the will, but by that beneficiary designation. Well, the thought is the court shouldn't be calculating the court cost on that. So that's an issue to be resolved. We've been at this for about 6 years now, trying to get some better guidance through the legislative process. We've had some success in getting closer to that point, and maybe the next session we will be. If there's anybody that is a member of the Iowa legislature or has good friends in the Iowa legislature, I'd like to talk to you at some point in time. But anyway, it's a work in progress. Otherwise, we just have to go by county basis and go through that process. Kind of the last piece of the probate costs that I wanted to touch on deals with attorney fees and the personal representative fees. Personal representative would be an executor or an administrator. If you have a will, we call that person the executor. And if you don't have a will, we call that person the administrator. Same type of roles, but the fees are calculated, are based upon a statute. And statute says those fees for the attorney or the personal representative can be no greater than 2% of the size of the estate. It doesn't mean that it's an automatic 2% fee applied. It just means that the fee cannot be greater than 2%. That's a whole nother story I won't even get into for tonight, but it just kind of gives you an idea of information about what those fees could be. Sometimes it can be higher than 2%. If there's the disputes, if there are some tax issues or real estate problems, those can also go above that 2% fee. All right, changing topics a little bit now to revocable living trust, as referred to as sexy estate planning. Well, in the world of trust and estates, we got to find something to get us excited, so we kind of go with living trust. And really, it's gotten a lot more attention over the past several years. In some states, probate is really a long, difficult, expensive process. California, for example, it's not a quick process. It takes months to get into the court system, and the costs are much higher than it is here in Iowa. So you might see a lot of writers or individuals that are in the public eye that say, hey, you need to use a trust. A trust is the way to go, pushing everybody towards trust. Not all states are like California, thankfully, and Iowa doesn't have a reputation of being a horrible probate estate, but it can certainly be improved, or some things that could be clarified. But trust is for many reasons, and we'll kind of get into the reasons why people look at trust, is a way that we can deal with avoiding that probate process. But one of the first things I want to point out is when you talk about trust, it's a very general term. And there are different types of trust, multiple types of trust. Just like saying I have a vehicle. Well, you can have a Mercedes or you could have a Yugo. But the types of trust that you can have what's called a testamentary trust. A testamentary trust, it's still a trust, but it's set up under your will. So your will that's going through the probate process can create a trust for young beneficiaries, for example. But you still have the probate process, and then that trust comes into life at that time. Another type of a trust is an irrevocable trust. An irrevocable trust is a very specialized type of planning device that you would use for either special tax planning situations, some Medicaid planning scenarios, or some different situations that it's kind of more of a unique and narrow use topic. But that's another type of a trust, an irrevocable trust. Charitable trust, there are some tax planning methodologies where you can utilize a trust to get some income tax benefits and also provide for a charity of your choice. But those are different types of trust than what we're going to be talking about tonight. But just kind of going through different types of trust besides the one on topic tonight. There are Medicaid-related trusts that are very specialized for dealing with certain Medicaid qualifying issues. Again, we're not going to cover those tonight because we have a limited amount of time. But as you can see, just saying, hey, Matt, I need a trust, that really doesn't get us all the way there because there's so many different ways of utilizing a trust. So tonight we're talking about revocable living trust. Some attorneys call it revocable trust. Some attorneys call them living trust. Some attorneys call them revocable living trust. Some attorneys call them intervivalist trust. And some people call it family trust. Tomato, tomato, it's the same thing. It's the same type of trust with just a different name we like to throw onto it. It makes it sound kind of cool when we say it's intervivalist trust. I prefer to use living trust just because we kind of focus on that this is a trust that we create that it's living now. It's the effect right now. The term revocable just means that you can change that trust. So you can modify it, you can revoke it, you can do away with it. It gets confusion comes into place when you have irrevocable trust, revocable trust. So that's another reason why I kind of utilize the living trust. But different terms, different strokes for different people. So, okay, why do we use a trust? Well, principally, the number one reason why we utilize a living trust is that it allows us to avoid the probate process. So everything that Hope was talking about, there's a lot of steps that are involved. The court costs that I were talking about, those are some probate costs. So some people want to avoid probate. A living trust does not provide any asset protection. So if you get sued and if you have a living trust, those assets are going to be vulnerable. It does not provide any Medicaid planning. So if you set up a living trust, it doesn't deal with getting you eligible for Medicaid benefits in the future. Because again, you have control of those assets, so you're still going to be able to use those for your long-term care. It doesn't provide any special, unique tax planning by itself. It can provide some tax planning, but you can provide that same type of plan with a trust, living trust, or with a will. So it's not a unique instrument and just it's the only way to accomplish some certain tax goals. So really, primary purpose of a living trust, avoid probate. So why is probate so bad, Matt? Well, there are a few issues where it becomes more obvious as to why people want to avoid probate. One is cost, and we kind of went through some of the costs. You have the court cost. Again, that's about 0.3% of the size of the total estate. You also have the attorney fees. I mean, those are the good guys, but there are some costs that go along with that. You also have potential fees for the executor or the administrator, and they're about 2%. So if you take 2%, and that 0.3%, you're getting about 4.3% as your approximate cost of going through probate. So if you take your estate, apply those types of costs and fees, you'll kind of see that, well, there's some expenses associated with that. So that's one reason why people want to bypass that probate process. The other issue why people like to avoid probate, and Hope mentioned this earlier, is that it's public record. Anybody go down to the courthouse, open up a court file, and they can say, oh, I see how much somebody inherited, how much money somebody had when they died, and information like that. So I grew up in a small southern Iowa community, and my mom was friends with the clerk of court. And so, they'd be having their discussions, and she would hear, well, did you hear how much so-and-so had when they passed away? And next thing you know, the whole town knows how much money somebody inherited, and everybody's gossiping. And before long, they're a billionaire with trillions in foreign accounts. And so there's some public availability that some people don't like. They want to maintain some privacy about what they have, what their family is going to be inheriting. In my 22 years, I've had one client, I think he's deceased now, but we talked about the subject of whether we want to do or a will or a living trust. And he was a single guy, which explains a lot, but he said, you know what, I'm kind of damn proud of what I did in my life. I want everybody in town to know how much money I have when I died. So he was one where he did a will and recognized that the whole town was probably going to know how much money he had when he died. For most people, that's not something that they're looking for. But for some people, it is. But it's you might have the ex-spouse, you might have nosy family members, nosy friends, just where you want to maintain that kind of out of that public eye. If you're visible in the community, maybe the local newspaper will have an article about how much money you had or how much money you inherited. So in this day and age where we have fewer and fewer limits on our privacy with social media and access to the internet, this is just a way we can try to limit access to that information. Another issue where probate is, again, dealing with a black guy, is if you have property in another state. So let's say you have, well, this time of year, we'd all like to have property in Arizona where we can get away from the snow and the ice. But if you do have property in Arizona, you're dealing with probate not only Iowa, where you are a resident of, but you're dealing with probate in Arizona, where that property is located at. And if you have a summer cabin up in Minnesota, you're dealing with probate in Minnesota. So potentially, all of those court costs, all of those attorneys, all of that information, it's just compounds the probate process. So again, that's where we look to getting out of probate. I don't want to make you feel that everybody has to do a living trust. When I meet with clients, I tell them this is what a will does, this is what a trust does, and you can decide what's the appropriate route for you, because it's what your neighbor uses might not be the right answer for you. So it's a personal decision to decide what's the right answer, because it does cost more to get a trust set up, and there are some issues associated with a living trust that can cause problems down the road. So it's not just the answer to everything, but it does provide some benefits. So when you're looking at a trust, basically it's a will on steroids. It does everything that a will does. A will says who your beneficiaries are, who's involved in the process, and the trust is the same thing. It says who's in charge of the process. We call them the trustee. It tells who the beneficiaries are and any restrictions on those beneficiaries. So the trust does all of those things, just like what a will does. So I can accomplish the exact same plan for a family with a will or with a living trust. So they do the exact same thing. It just matters how you get from point A to point B. We also want to focus on what the trust doesn't do. The trust only controls the assets that are titled in the name of that trust. So assets that have those named beneficiaries, your retirement accounts, your POD accounts, like Hope mentioned, there are the TOD, payable in death and transfer in death. Those are not going to be subject to what that trust says. Only the assets that are titled in the name of that trust are going to be subject to the control of that trust. What that means is that a key point of having a trust is transferring those assets into the name of that trust. So I could generate a great document, well, some people don't think it's so great, it's not much fun to read, but a great document that says everything that you want to have happen upon your passing. But if we don't put those assets in the name of that trust, that's a worthless piece of paper that didn't get accomplished what we were looking to get accomplished. So the key step is we want to take the assets, title them in the name of that trust. There are some exceptions to that. Vehicles, we don't have to retitle vehicles, they can stay in your name. Assets with PODs and TODs, those can be changed, but they don't have to be. You might say, those are perfectly fine as they are, so we can keep them in that fashion. Or any other accounts that have beneficiaries. Retirement accounts, IRAs, where you've identified a beneficiary. You don't have to change it to the trust, but you can, or you want to make sure that everything is reviewed and lined up so that you understand that this trust controls these assets and the beneficiaries control these assets. If you have a situation where you don't get assets into that trust and you die, Well, that's the first bad news. The second bad news is you're going to have to go through probate. And when you go through probate, it's not just that trust, it's not just that asset was outside of that trust, it's all of the assets get dragged into the probate process. So you're dealing with the court cost on all of those assets, trust or not, court cost and attorney fees, all dealing in that probate process. So that leaving an asset out is a key problem that we see as one of the downsides of a trust. To give you an example, I had a client that we set up as trust for. He was in his 50s, so still fairly young, and we took all of his assets, got him over into the trust. Things were fine. Then he went out and bought another farm. Great, but he didn't put the farm in the name of the trust, and unfortunately, 30 days after he bought that farmland, he ended up dying unexpectedly. And now, as a result, that farm is outside of that trust, and we have 95% of his assets are in that trust, but because they have that farmland out, we're dealing with that probate process. So that's one of the biggest risks that you have with that trust, is making sure not only assets that you have when you set it up, but assets that you acquire later on. Kind of moving on a little bit on a different topic related to the trust is the job of the trustee. And being a trustee is not a walk in the park. The trustee is going to be dealing with the investments. So stock markets change on an hour by hour, minute by minute basis anymore. So they're going to have to deal with all the investments. They're going to have to be answering questions from the beneficiaries potentially. They're going to have to be dealing with distributions, dealing with tax returns, dealing with the CPAs, attorneys, financial advisors. So it can be a fair amount of work. Now, for those individuals that have their own job, their own career, their own family, their own activities, hobbies, they may not appreciate being the trustee. So many people will try to maybe they'll have their kids doing it, or one of their kids be the trustee. And that's perfectly fine, but again, we just want to make sure that being aware of that job demand is something that might be more than what they're able or unwilling to tackle. The other thing about naming an individual as a trustee is that all of a sudden you become the target. People will second guess what you did. Well, why didn't you sell the stock when it was at that high? Why did you wait to sell it later on? Why did you buy this land or sell this land? And people start questioning what you're doing. And unfortunately, that leads to lawsuits. And that's where the attorneys get rich again. But those lawsuits, I've had lawsuits where children have sued their own parent for mismanaging the trust funds. I've had nephews and nieces that have sued aunts and uncles. Obviously, nobody anticipated this. These people didn't expect their kids to sue their own parent. They didn't expect their sibling to be sued by their own kids. So it becomes a problem later on when maybe it's innocent mistakes, maybe it's not so innocent. So naming an individuals, we have to be careful about that. So you're probably saying, well, if I don't name individual, who do I name? We name Hope. No, you don't. You can, I guess. But what we kind of also encourage people to explore, it would be looking at naming a bank as a trustee. A bank has a staff, they have the resources, they know what they're doing. They are very efficient. That's their day job, is managing these assets, dealing with tough questions, dealing with the CPAs and tax returns, the investments. So that's their job. Not every bank can be a trustee. So certainly before you name a bank, you want to visit with them to make sure that they are able to do those types of services. And they'll be glad to sit down with you and talk to you about their fee structure. Their fees are generally pretty uniform, at least here in central Iowa. They're about 1% on the first million, and then above $1 million it goes down from there. But talk to them about their fee structure, how they handle distributions, and you might be surprised as to kind of the approach that they take. And so we just want people to open their eyes to consider utilizing a bank. It doesn't mean you have to change all of your bank accounts over to the bank now. So you could have everything with one bank, but let's say they don't have a trust department. Well, that's fine. you can have another bank that does have a trust department as your successor trustee. So upon your passing, then that new bank will step in, be your trustee. They'll get control of the accounts at that time, but you don't have to do anything during your life. They're just there on standby mode. If a bank makes a mistake, and banks do make mistakes, I'm not going to sit here that they're perfect answer, but if they do make a mistake, they have the resources to back up and make right if there was a mistake. If you have an individual that makes a mistake and their individual is a trustee, they may not be able to pay back the beneficiaries for what the loss was. This is just kind of repeats what I just said earlier out of order, but like I said, individuals have real jobs, so we kind of want to make sure before we name individual that they're capable of doing that and able to do that. And individuals are also entitled to a fee. Some people think, well, banks cost too much. Well, individuals can take the same fee as well. And they don't always do as good of a job as a bank. So that's one thing. You're not necessarily saving money by naming a bank. You could be having higher costs by naming an individual versus a bank. Just to make sure, I don't work for a bank. I'm not here to promote banks, but just from experience, I want to make sure people kind of explore that option. Beneficiaries, and then we'll be able to conclude here a minute after I was supposed to conclude. But beneficiaries, we want to look at, are they ready to handle that money? So we look at age. I have a 22 and 18-year-old. Good kids, but I'm not too sure they're ready to receive the money. So we want to control that money for a certain age time before they're ready to receive that inheritance. Financial maturity. Some kids in their 30s, 40s, or 50s are not financially mature, and so we may not want to have them handle the finance or receive the finances. Maybe they have creditor problems. Maybe they started a business that didn't go well. Bankruptcies looming on the horizon. Maybe they're getting ready to go through a divorce. Maybe they have some type of a disability, special needs situation. We want to look at all those situations and say, are they ready to receive an inheritance? And if they're not, we want to kind of manage those funds for them. And we also want to look at the situation of, if that beneficiary is not surviving, then where does that money go? Does it go to their children? Does it go to a spouse? Does it go to a charity? We also want to look at tax issues, which again, it's kind of beyond the topic, but it's something we want to consider when we're going through that whole estate planning process. That's proof that I can wear a tie at some point in time, but that's me. So with that, I guess we'll open it up to questions.
So I can start you off with a question. We talked a little bit about what happens when you acquire more assets and you have a trust, and considering whether you might want to put like farmland in a trust if it's acquired after the trust is formed, if I'm using those terms properly. What do you do the same thing when you have a will? Do you need to change your will every so often? And where should you keep your will, and where should you keep copies? And for trusts as well, perhaps.
Let me start with the last question. Okay, so the last question was, where should you store the will? And I think, should you make copies? I think different attorneys are going to have different answers for this. I recommend, well, definitely keeping the original will, which is the one that can be enforced, keeping it in a place that is protected by natural disasters. So a fireproof box or a safe at home. If it has a key or a code to get in, make sure that your executor knows how to get into that. Otherwise, they may not know where your will is. So if you have a small firebox that's under your bed and your executor doesn't know about it, then they may not even realize that there's a will. And this has happened to me before, where an intestate estate has been opened. We did an application to waive bond. So you want to name the executor somebody you trust and let that person know where you've stored your will. If you do choose to use a safety deposit box, then you have to make sure that you have someone that is on that account that can access the box after your death. Because if there's no one named, that bank can require an estate to be opened and an appointment letter of an executor administrator just to see what's in the safety deposit box. There may not be a will in there anymore. So from a personal standpoint, I encourage people not to use a safety deposit box unless they're sure that it's set up so that the executor can access it after that person dies. I don't recommend making copies of the will. The will is a private document, so you don't have to share it with anybody. Copies sometimes can be interpreted as an original, and then they try to admit that for an estate. I had that happen, and we had to track down the original will or go through a very sort of complicated process through the court to validate a copy. So I discourage copies, but again, every attorney is going to be a little bit different on that. So that was the last question, Virginia. I know there were maybe two others in there too. The farmland question.
How often
And
do
updating a
you
will?
recommend updating a will?
For me, usually when there's a life event that happens, either to your family or somebody that you've named. So if you have done a will and you named your spouse as your executor and your spouse is no longer alive and your alternate executor is older than you, it's probably a good idea to update it, to update that executor. If you have additional children or grandchildren, your child, you don't necessarily have to update the will to add that child's name. Usually the will or it should be drafted so that it includes children born or adopted after the will's written. And I believe there's a statute that also provides for children that are entitled to inherit. So, and if there's ever any concern whether you should or not, I would encourage you to talk to an attorney, or as Harry had mentioned, to find a lawyer and the free resources there. There's also a platform called Iowa Free Legal Answers, where you can post your own question and an attorney can answer those. So you don't necessarily always have to, call up and ask the question. There are some resources where you can reach attorneys. And I'll let Matt answer the farm question.
And a couple others have come in related to that.
I'll just briefly answer it the way I remember it, and I could be wrong, but I'll do my best shot. As far as retitling assets, we talked about the trust retitling the assets for the real estate, and that's a given. I think maybe the question was other assets, or if you don't have a trust, retitling assets. And I think Hope also touched on that you don't necessarily have to retitle those assets if you're using a will as part of your estate plan, but you also want to be aware that if you have that jointly owned property, titled jointly owned with your spouse or whoever, that asset, farmland or whatever, it's going to pass to that joint owner. And that joint owner, then at their estate plan, can certainly modify where that property goes to down the road. And so if you have a second marriage where you have his and her children, and you have assets that are jointly owned, they go to your spouse, and your spouse says, well, I never liked those stepkids to begin with, and they have the ability, the surviving spouse, the step-parent, can then change their will to cut out the stepkids, and then have a lot of fun dealing with that problem. So whether that addressed the question or not, I don't know, but we'll just consider that good information for now. The other thing I was just going to supplement a little bit to what Hope said on reviewing your estate plan or reviewing your wills, trust documents, they don't expire, but in addition to what Hope said, I think it's every 4 years. We kind of follow a 4-year review recommendation of let's at least do this every 4 years, if not earlier, but things change pretty quickly, as you know, and so 4 years is kind of the time period that we utilize for those. So go to the next question.
Sure. What happens, I'm going to start with a more general question here from one of our 17 libraries across the state. I believe this one's from Urbandale. If you don't have a spouse or children, who receives your assets in probate, and what's the order of inheritance?
Way to go, Urbandale. If you don't have, I'm going to assume that the question is if you don't have a will and you don't have a spouse and you don't have children, where do your assets go? In Iowa, there's a statute, the Intestate Statute, which says who your presumed beneficiary. So it kind of follows the family tree. And so if you don't have any children or grandchildren or great-grandchildren, then it goes, and then you'll be going up, and we're assuming you don't have any parents or grandparents, then it would go up to your siblings if you had any siblings, and if you don't have any siblings, or if a sibling's deceased, then it goes over to the nephews and nieces, and it kind of works its way as you would probably think that it would be. So it's extremely unusual or rare for it to go to the state of Iowa. Some people think that the state of Iowa gets all your money if you don't have a will. And that's not accurate. In my 22 plus years, I've never had anything go to the state of Iowa. We always find some beneficiary. Sometimes it's been on different continents, different countries, and spread all around. And occasionally we get those laughing errors. I had no idea who this person was, but all of a sudden there's a check in the mail from this deceased third cousin that had money that went to them. So there is a process, and the statute will set out who receives those assets.
And if you don't mind, I'll put some questions together regarding what happens with assets related to trusts. For example, if you have personal property such as antiques or collectibles, how do you transfer those into a trust? Is that getting perhaps to where you want to contact someone for help or look at some additional resources? Also, if there's a vehicle in a trust that is sold and there's a new purchase, does the new vehicle or something that is newly titled need to be transferred into the trust's name? It sounds like, I don't want to answer for you, but.
Well, it always depends on what kind of asset it is. This is probably a better question for Matt in terms of how to title the personal belongings into the trust, so I'll hand it back to him.
I told you would take the hard question. So if there isn't a piece of paper that says somebody owns this like for example, if your house, you have a deed or an abstract which demonstrates you own that asset. For those assets that you don't have a piece of paper that proves you own it, what we typically do, we just kind of have a document which transfers all of our personal property. So I have furniture and other miscellaneous items around my house that you can transfer everything over to your living trust. So that's how we handle those types of assets that don't have a proof of a title for that. As far as the vehicles question, I guess I'll preface it by saying we generally don't recommend putting vehicles in the name of that trust. You can, but it's not a requirement to have a vehicle titled in the trust. If a vehicle is titled in the trust and the trustee will have control of that vehicle at that time, they would sell it and those assets go back into the trust to be distributed with the rest of the assets. So.
If you have...
Just a second. There's one right behind you first. I'm sorry.
Okay. My question is regarding a will. So my situation is my mother-in-law, my husband, and his brother all own the home. So if she were to die, then is it just automatically transferred to the two children? And what would is there inheritance tax then, or because their name is already on the home ownership?
Okay, so the question is there's multiple people on the deed. The deed will state if it's a joint tenancy with right of survivorship. So if everyone owns it that way, and one of those joint tenants dies, it will automatically transfer to the surviving joint tenants.
Okay, they don't live there, so they're not tenants. Okay, but they're
Sorry,
still called
yeah,
tenants.
it's just it's a legal term. Joint
Okay.
tenancy is a way to describe how real estate's owned.
Okay,
or an
so
asset is
there
owned.
wouldn't be an inheritance tax because they're partial owners?
The inheritance tax is dependent on the relationship to the person that died. So it's irrelevant as to whether they how they inherit it, but how their relationship is to the person that died. So.
They're the children.
The children of, like
They're
the
adult
parents.
children, right.
Adult children, then they'd be exempt from inheritance
all right,
tax.
thank
yeah.
you.
People that aren't exempt are cousins, in-laws, things like that.
There you go. Will you use the mic first?
Oh, sure. If you set up a revocable trust, and then after it's set up, you purchase equities, bonds, or something, you were saying like the guy who bought the farm, it was outside the trust and all that. So how does that work with equities? Can you just, if your bank account is set up in the trust, and if you buy it through the bank account, then does it automatically go into the trust, or do you have to name those equities into the trust?
A new, like outside, separate and outside of the
okay.
bank?
You set up a trust and you put all of your assets in it, then you buy a new equity, a new stock or something.
Usually you'll want to title it in the name, well, it depends. You don't necessarily have to put that asset into the trust, but you want to do like a designation of who's going to receive it.
Yeah, but if you don't put it in the trust, then you run the risk of throwing the whole thing into probate, don't you?
Unless there's an option to have a beneficiary named,
Okay.
then that asset would transfer to the
How would you just
beneficiary.
put it into the trust with any other equities that you have? Would you just,
When you take it out, or when you purchase it, you would put it in the name of what, the trustee?
Yeah, I guess what I would do, like, if you, sorry, towards that.
No, it's okay.
Let's say you have like an Edward Jones account, or a Charles Schwab or whatever. So you have an investment account, and whatever assets that account owns, they will be inside that trust. So as long as that account is titled the name of that trust, whatever you buy and sell, it's going to be in that trust. Now, if you have stock certificates, please don't, but if you did have the actual stock certificates, you have to send them back to the company or their transfer agent and have it retitled in the name of the trust, and they'll send it back to you. It'll have that trust name. So ideally, if you have stocks or equities in the name of that trust or the account in the name of the trust, that's what you'll want to accomplish.
We have a question back here.
So I have a question when it comes to looking at calculating the value of an estate when it comes to probate. So if you have accounts like an IRA or CDs that already have the beneficiaries listed, are those included in calculating that? Or if you, so say for example, you've got a house, checking account, savings account, then you have these CDs, life insurance, and IRAs over here that already have beneficiaries listed. Are all of these, the IRAs, are they included when you're calculating the probate, figuring out large versus small estates?
Yes and no. Is that a good answer for you? Yeah. The question was calculating the costs when you have assets that go by a beneficiary, for example. And when you're looking at calculating probate costs, it's going to incorporate all of those assets. So whether they have beneficiaries or not is irrelevant. If you own an asset, it's going to be included in the calculation of those expenses. I thought I was pretty clear on the question to your last comment about the small estate. The small estate is a little bit different. You could have $1 million size wealth at your death, but potentially you could go through a small estate. To give you an example, let's say, I'll be easy math for me because it's late. $1 million estate, but you have $900,000 that's in an IRA that you have a beneficiary. But you forgot about a bank account that has $90,000 in it. In that situation, that bank account is the only probate asset. So you could be a small estate even though you have this $900,000 IRA out there. So that's kind of a little disclaimer on your question, I guess. And insurance would not be calculated as well, it's separate too.
Does joint tenancy with right of survivorship overrule a spouse's interest?
So if let's see. Does joint tenancy with right of survivorship like supersede what the spouse could inherit? The spouse has the right to elect to live in the homestead during their lifetime. So if the spouse isn't the joint tenant on the deed and they're written out of the will, then the surviving spouse does have options, unless there's like a prenuptial agreement that, excludes certain things. But the law is written to protect the surviving spouse from becoming, without any funds. There's also a right to inherit other parts of the estate under a spousal election. It just sort of depends on the situation. But if the spouse that dies jointly owns the house with a child and the child doesn't live there, but the surviving spouse does, that spouse can elect to stay there.
Is there anything different with a dower, a widow's share?
It's the same thing, isn't it? Yeah, it's basically the same thing.
Same thing.
Yeah.
Yep. Okay. And we have a couple of questions at this table.
I'm not sure I understood you right, but I want to double check.
Okay.
I thought you said that if there's real property with one owner, it will always require probate.
Right.
But the whole idea of having a trust is if you title the property into the trust, does that eliminate that requirement for probate or not?
Well, if the house, well, I'll just use the house as an example. And what Matt said is you can have your trust written, but you have to retitle your assets into the trust. So the house would need to be retitled or a deed issued into the trust. So, and that's often when I recommend a revocable trust is if the surviving spouse is the only owner, you can avoid probate by creating a trust and then doing a deed to transfer it from that one owner into the trust.
I think maybe to clarify, the comment was if it's an individual owner, of that asset, it will require you to go through probate. If it's a trust that owns that asset, then should be able to avoid probate. Does that help? Should? If there are other assets that do not get involved, or were not in the trust, then everything gets dragged back. So if you have two houses, you have one house titled in the name of that trust, and you have one house titled in your individual name with no joint owner, because of that one asset being titled in the individual name, that's going to drag everything into the probate process.
So in other words, if you have a lot of POD accounts and beneficiary accounts, you get the house out of probate need by putting it in a trust, you reduce your probatable assets to a point that's below $100,000 that you can use small estate.
You got it?
Speaking of PODs, how do you put old savings bonds into PODs?
I've had to do that myself personally. Oh, so the question was, if you have a savings bond that doesn't have a payable on death designee, how can you name someone? The savings bonds are issued through the Treasury Department, and they now only issue electronic bonds, so it makes it a little easier to add that payable on death designee. So what you have to do is create an account with the Department of Treasury and transfer them into an electronic status, and then through that account you can name a payable on death designee. And it's not very easy. I've done it, and the website is difficult. So if you have somebody that's good on the internet and good with forms and stuff, have them help you, because it does take a while.
If you have a named trustee, and then for example, take my sister, she has a named trustee, she dies, and the trustee can't do it, how do you get a new trustee named?
So if there's not an alternate trustee listed in the trust?
Yes.
somebody petition?
Or even if your other alternate can't do it. For example, my sister, she named my nieces.
Yeah.
They have no idea what they agreed
Yeah.
to,
Okay.
on how to do it.
Yeah.
And they're young and they've got a lot of things going, and some don't even live in the state. So how do you, if they say, I just can't do it, then do you just help them do it, or do you get someone else named?
Well, they could do that. They could have, get a fiduciary assistance with that, which would be an option. And I'll let.
If the trust is silent on a way to name a successor trustee, sometimes it might say, if there is no trustee that's serving, then a majority of the beneficiaries can identify a trustee. If the trust is silent on a process to do that, then the next step is you go to court, and the court can step in, and you would say, hey, I want this bank to be the trustee, assuming the bank agrees to do it, and then the court would appoint him as a trustee, and then basically the court steps away. So it's kind of a temporary process to get involved to get the trustee appointed.
So it would be better to go back to the sister and say, make sure you've got a good alternate.
Yes. Yeah, I normally recommend having at least one of the backup or a system to identify a process to name a backup.
Could you please talk about using a signed and dated list for naming who gets personal property?
Sure. Hope seemed excited about to answer this one. So,
I like wills.
The personal property items are the things that can cause a lot of family issues. I've had people fight over T-shirts, people fight over pictures, a toaster. So there's just things that can create some concerns. But Iowa allows you to say, hey, I want my wedding ring to go to my daughter. I want my 12 gauge to go to my grandson. So you have the ability to identify where those special items are going. It doesn't have to be financial value to them, it's that sentimental value. So it's an easy way to handle distributing out those types of heirlooms.
I just wanted to add too that in Iowa, there is a code section that says you can update that list, or you can keep a separate list of personal property, so that you don't have to go back and change your will every time you have a new belonging that you want to go to somebody. So a lot of times it will be in the will that says there may be a separate letter designating who gets what personal property, and you can if that is your will, you can update that as you want to. It just has specific requirements. You have to date it and sign it and put a description of what it is and who it goes to. So that is an option.
Okay, so now I have two questions. So you could either itemize it or say all my household furniture goes to this person, and you could actually, you don't have to go item by item.
Right,
but
yes.
You could group it.
Yeah, and that was actually one of the things that kept me from doing a will, was I don't know who I want to give these certain things to, and I didn't realize that I didn't have to decide who my furniture was going to go to. I could just say it all goes to my spouse. So that's what the default is it all goes to the person that you've named to receive your personal property. But if there is a specific list that's either referenced by the will or separate, or in the will itself saying my jewelry, you want to, if it's jewelry, you want to list specifically what it looks like. Don't just say my grandma's ring. Specifically describe what the ring is, but that will be distributed first before that will go to the person that you've named, as long as they're alive.
My original question was actually for the trust. So if you own property in another state, you would have to go through probate through 2 states. If you live, like you go to Arizona and you have property there, and then you'd have to do it, one for Arizona and Iowa. But what if you're just traveling there maybe 5 months out of the year, but you don't, and you're renting, you're not actually owning property? do you have to go through probate there? Probably not. but-
Probably, yeah, probably not. Unless there's, so, I mean, it depends on that state's law, but yeah, probably not. I mean, because it's going to be just personal property in the.
If you were to die there.
Yeah, in the rental, yeah. Now, probate is, again, required if that state requires that a certain asset has to transfer through the court. So I did a estate plan for a person who had a rental property in Colorado. And so we took care of the Iowa homestead here with the trust, and I advised her to talk to an attorney in Colorado to create a deed where it's titled in the trust for here. So it doesn't necessarily automatically require probate because you can encourage them to do. Yeah. Yeah, but I can't do a deed for Colorado because I'm not licensed in Colorado, so.
Is there an exception, or should you kind of draw a cutoff point where on these lists, when it starts to involve extremely high value items like artwork, extremely valuable musical instruments, jewelry, that kind of thing, does that fall into a different category, or do the lists still apply?
Nope, it doesn't, yeah, it doesn't matter the, like, market value.
Okay.